Hi, I'm Deb Sullivan, and I'm a board member of the Labor Guild of the Archdiocese of Boston. Today we're going to talk about the Landrum-Griffin Act. What is it, what it does, and how it differs from the National Labor Relations Act. In order to understand the Landrum-Griffin Act, or LMRDA, we need to step back in time and examine labor history in the United States. The LMRDA was formerly known as the Labor Management Reporting and Disclosure Act, which is why it has such a long acronym. If we are to go back to the early 1900s, the country was in a time of unrest. This was a tumultuous period in the United States as we were just coming out of World War I, and there were massive strikes that shut down the nation's coal, steel, and other industries. The American Federation of Labor, or the AFL, had just been formed in 1886 and existed as an umbrella organization that primarily protected the rights of skilled craftsmen. There were a lot of workers left out, and there was a real need to find ways of protecting those workers. Into this void came the Wobblies. Wobblies were members of the Industrial Workers of the World, or the IWW. They incorporated in 1905 and were eager to organize unions based on industry lines, as opposed to the specialized trades or craft unions. Wobblies were feared by both big industry and the AFL, so a smear campaign labeled the IWW as radicals, anarchists, and socialists, and called it a revolutionary labor movement. Nonetheless, the IWW was very effective in the early 1900s with their short-term goals, and by 1917, they had organized more than 150,000 workers across the United States, Canada, and Australia. The United States government was afraid. This period of time is known as the First Red Scare. There were severe crackdowns on groups that stepped too far out of line. Examples of this include the infamous Bread and Roses mill strike in Lawrence that occurred in 1912. Nonetheless, workers held their ground and continued to fight for better working conditions to improve their quality of life. The Colorado Fuel and Iron Strike of 1914 changed everything. This bloody strike happened because Colorado Fuel was a subsidiary of Standard Oil, John Rockefeller's company, and his son, John Jr., had inherited it. When Colorado Fuel went on strike, Jr. and the other board members were determined to break it, whatever it took. After a long period of unrest, the Ludlow Massacre happened, where over 20 men, women, and children were slaughtered. In order to regain the good name of his family and rehumanize the Rockefellers, JDR Jr. sought expert advice from the new field of public relations to settle the strike. This settlement resulted in the establishment of a Management Labor Conciliation Board, which quickly evolved into a company union and became a template for settling most labor disputes of the time. Although a step forward in labor relations, the company union was effectively a public relations ploy that resulted in upsetting and tamping down the efforts of trade unions in the great organizing drives of the period. Oppressed under the weight and control of these company unions, workers rebelled, and the National Labor Relations Act, NLRA, which is also known as the Wagner Act, was signed into law. The act was written by Senator Robert Wagner, approved by Congress, and signed into law by President Roosevelt. This was a monumental shift and created a foundational statute that guaranteed the right of private sector employees to organize into unions, engage in collective bargaining, and most importantly, allowed unions to take collective actions such as strikes, the ultimate source of power for unions. Central to the act was a ban on company unions. The NLRA sought to correct the imbalance of power between employers and employees by promoting collective bargaining between unions and employers. The law established the NLRB, National Labor Relations Board, to prosecute violations of labor law and to oversee the process by which employees decided whether to be represented by a labor organization. It also established various rules concerning collective bargaining and defined a series of unfair labor practices or bans, which included interference with the formation or organization of labor by employers. However, the Act did not, and still doesn't, apply to certain workers, including supervisors, agricultural employees, domestic workers, government employees, and independent contractors. No surprises here. The NLRA was strongly opposed by conservatives and members of the Republican Party, but it was upheld in the Supreme Court in a case decided in 1937. In 1945 and 46, an unprecedented wave of major strikes affected the United States. By February of 1946, nearly 2 million workers were engaged in strikes or other labor disputes. Organized labor had largely refrained from striking during World War II. Labor leaders were ready to share in the gains from a post-war economic resurgence. The 1946 midterm elections left Republicans in control of Congress for the first time since the early 1930s. Many of the newly elected congressmen were strongly conservative and sought to overturn or roll back New Deal legislation, like the NLRA. Republican Senator Robert Taft and Republican Congressman Fred Hartley, Jr. each introduced measures to curtail the power of unions and prevent strikes. The Taft-Hartley Bill that emerged from a conference committee incorporated aspects from both the House and Senate. The bill was promoted by large business lobbies, including the powerful National Association of Manufacturers. Although it was enacted by the Republican-controlled Congress, the law received significant support from congressional Democrats, many of whom joined with their Republican colleagues in voting to override the veto of then-President Truman. Labor leaders at the time were furious, considering this bill to be nothing more than a slave labor bill. Among the practices prohibited by the Taft-Hartley Act are jurisdictional strikes, wildcat strikes, solidarity or political strikes, secondary boycotts, secondary and mass picketing, closed shops, and monetary donations by unions to federal political campaigns. The amendments also allowed states to enact right-to-work laws banning union shops. Also, because it was enacted during the early stages of the Cold War, the law required union officers to sign non-communist affidavits with the government and declare their undivided loyalty to the United States of America. Following the inception of the Taft-Hartley Act, the number of union victories in NLRB-conducted elections significantly declined. During the 12-year administration of the Wagner Act, unions won victory over 80% of elections. But just in the first year after passage of the Taft-Hartley Act, unions won only around 70% of the representation elections conducted by the agency. During the middle and late 1950s, the labor movement was under intense congressional scrutiny for corruption, racketeering, and other misconduct. This was the McCarthyism era. By 1959, Congress concluded that further reforms were needed to address gaps in both the Wagner Act and the Taft-Hartley Act. In the fall of 1959, President Dwight Eisenhower signed into law the Landrum-Griffin Act, or the Labor Management Reporting and Disclosure Act, LMRDA, that amended Taft-Hartley and established required reporting for labor organizations and surety companies, standards for the regular election of union officers, and safeguards for protecting labor organizations' funds and assets. The centerpiece of the Landrum-Griffin Act is Title I, which provides a Bill of Rights for union labor members. In August of 1958, Eisenhower gave his support to the Landrum-Griffin Act, which labor considered to be the most restrictive of the three bills that were introduced at the time. The House and Senate finally agreed on a compromise bill, and President Eisenhower signed it into law as the Labor Management Reporting and Disclosure Act in September of 1959. This act was essentially the Landrum-Griffin Bill, and so the act is more commonly known by the name of its two congressional sponsors. The creation of the Landrum-Griffin Act instituted federal penalties for labor officials who misused union funds, who had been found guilty of specific crimes, or who had prevented union members from exercising their legal rights. The act contained other provisions that strengthened parts of Taft-Hartley, which was detested by nearly all factions of organized labor. These provisions included a strict ban on secondary boycotts, union efforts to stop one employer from dealing with another employer who was being struck or boycotted, and greater freedom for individual states to create and determine labor relations within their own borders. The latter provision hampered labor organizing in the South, which remains the least unionized region in the United States to this very day, and became part of a broader Southern strategy. Other parts of this new law established a code of conduct guaranteeing certain rights to union members within their respective unions, and imposed strict reporting requirements on unions, union officers, employers, and consultants. These provisions were assigned for administration by the Department of Labor. Thus, the Landrum-Griffin Act protected employees' union membership rights from unfair practices by unions, while the National Labor Relations Act protected employees' rights from unfair labor practices by employers or unions. The Secretary of Labor enforces certain provisions of the LMRDA and has delegated that authority to the Office of Labor Management Standards, OLMS, of the Department of Labor's Employment Standards Administration. So, the Landrum-Griffin Act deals with the relationship between a union and its members. The Act grants certain rights to union members and protects their interests by promoting democratic procedures within labor organizations. Its intent is to provide employees union membership rights from unfair practices by unions and differs from the NLRA, National Labor Relations Act, which protects employees' rights from unfair practices by employers. If you are interested in learning more about the world of labor and management relations, you can find more information through the Labor Guild's video series or enrolling in the Guild's School of Labor Management Relations. Courses are offered online as well as in person and are taught by experienced labor and management professionals and neutrals. For more information, visit the Labor Guild website. Thank you so much for taking the time to watch this video.